All right. Thank you, everyone, for taking the time to be here today. We're going to be talking about the COVID temporary tenant protections that were in place. Excuse me. Geez. It is brought to you, of course, by rpmeducation.org in partnership with the Portland Area Rental Owners Association. And the actual attendance part doesn't cover the continuing education credit side, but the attendance part is covered and free because it's also paid for by a grant from the city of Portland, Portland Housing Bureau, for that they spread around money to educate both landlords and tenants. And rpmeducation.org happens to be the only recipient for landlord specific education doing all these webinars. So you're here. It's free for you guys to be here because of that grant. Also, we're a couple months into it, but total there were 22. So I think now we've got, after today, I think we're on like 17 or so left. They go on the fiscal year. So from now through the end of June, we try to do 2 of these a month, basically. And they are all paid for free for you guys to attend. Of course, it covers all of the city of Portland specific ordinances and laws. But then there are also, this is the last of these COVID tenant protection related classes, but there's was these, as well as there's free classes on state law SB 608, like that covered the rent control, rent increase limits, and no cause notice reform, in those areas at the state level, as well as ones based on fair housing, specifically fair housing and the pitfalls and issues that, well-meaning landlords can find themselves in, and things to look out for to abide by fair housing discrimination law, all that type of stuff. So check rpmeducation.org as well as portlandarearoa.com. Both of those, both sites have all of those City of Portland paid classes on there for you guys to attend. Excuse me, sorry. Frog jumped in my throat right as I started the class. So hopefully it will be temporary. All right. So talked about the grant. And I think we're ready to go ahead and jump into it. Oh, of course, my clicker is on the wrong one here. There we go. In your class materials folder, if you are here, you got the email with the link to get here. Well, in another paragraph in that same email is a link for a cloud shared folder and the class materials. I will tell you, because of how quickly things can change and how many times they have extended tenant protections and replaced it with different laws of different details and everything. I really did wait until the last minute to update today's class, and so I think it was only an hour and a half to 2 hours, probably maybe 2 hours or so before the class started. So probably sometime around, probably by like 9:30ish, somewhere around there, I did update the class materials. If you happen to download and or print out the class slides prior to that, you're going to see a lot of things on your PDF that's not on here, and also not see some. Well, it has been updated, so you can go ahead and access that again real quick if you need an updated one. If you downloaded yours within the last hour and a half or so recently, then more than likely you've got the right one. But also know that access to that folder will stay open. So if for some reason you happen to not have the right one, you're willing to just follow along, don't really care about dealing with it right now, you'll still have access to it after the class. So don't worry. Anyways, excuse me. Either way, whichever version you have, you do have a nice printer-friendly black and white version of this slide we are looking at today. This was created by my liability insurance attorneys. Since you guys have a version of it in print, I'm not going to force you to listen to me read it word for word today. I'm going to assume you will take the time to read it on your own. The gist of it, though, is that I am not an attorney. My name is Christian Bryant. I believe my bio is in the class description and stuff, but as a quick recap, I'm president of the Portland Area Rental Owners Association, president of Northwest Real Estate Investor Association. I'm co-chair of the Rental Services Committee for the City of Portland. as well as serve on the legislative committee for the ORHA at the state level. And of course, I've owned and operated my own land, property management company in the greater Willamette Valley, Central Oregon, for going on 14, almost 14. Yeah, 13 and a half, almost 14 years now. So I wear a lot of hats. That gives me a good perspective and a good brain to kind of interpret the laws that apply for what we're talking about today. But none of that is any official legal opinion, as I am not actually an attorney. No matter how many of those hats I wear, none of them are that. I do always suggest, if you are a landlord, because the best thing we can do as landlords, and I'm sure even any tenant advocates or tenants would agree with this, the best thing we can do is make sure that whatever we are doing, if doing anything official with our tenants, that we are actually following the law and handling it properly, right? I mean, tenants, want those laws and their rights followed, but also landlords, of course, you want to make sure you're moving forward properly, as that's the cheapest way to go, because you don't expose yourself to any extra liability if you accidentally violate something like that. So one of the things I always say is an attorney in your area that specializes in practicing landlord tenant law and representing landlords, knowing who it is and who you're going to call if at some point you need their expertise, excuse me, is just as important, in my opinion, as knowing which emergency plumber you're going to call in the middle of the night if the pipes burst, right? It's the type of thing to where you probably won't need them for quite a while. And if and when you do need them, it'll be very few and far between. But when you do need one, you'll probably need one quick, and save yourself a day or two of actually hunting around and try and find a good one and get a referral, right? Do that work ahead of time, know who you're going to call. And also, don't be scared. Lots of times there's gray area in landlord tenant law at the state of Oregon level, city of Portland level, federal level, when you're talking certain things. If you find yourself in one of those areas, reach out to your local landlord support association. But if you're, still questioning exactly how you really should proceed, or maybe you let your emotion get the best of you earlier and said or did something you think you shouldn't have, that you want to know if legally you can kind of, take that back or whatever, and how to proceed. It might be cheaper, spend $500 officially consulting with a landlord practicing attorney, and to make sure that you are proceeding properly. So don't be scared of attorneys if you need one in their opinion. Anyways, geez. All right. Of course, what's on my slides has been approved. But with that said, no one can actually control what comes out of my mouth. So if I say something totally crazy, don't hold it against any of those that are responsible for me being here. With that said, in the 10 plus years I've been teaching these, I haven't gotten myself in trouble, so we should be okay. Feel free to ask questions. Do try to keep it organized though, if you can. Makes things easier for everyone. Try to use the chat for you guys chatting amongst yourselves, if you want to, sharing links to stuff, something like that, as a couple of you already have done, and I will be asking for here at the end of this slide. Doing the continuing education credit check-ins, things like that. Use the chat window. If you have a question that is on topic for what I'm talking about today, for me to read aloud and answer as part of the class, then if you can, please try to use the separate Q&A section. Just makes it so that if we do end up with a lot of questions, keeps things organized, so you guys don't have to listen to me sit here and read through the chat trying to find the questions. So just try to keep that organized. Also in the Q&A section, if I haven't answered a few questions yet, you can just give a thumbs up to ones that are the same as yours instead of doing a repeat, and it'll make it a little higher priority on my side too. So try to use that separate Q&A section if you can. Let's see here. I always schedule myself to stay later than the class is scheduled to end, just in case, if there are any, if there's a question I didn't get to, but also if you're going through the class and you're reminded of, oh, hey, I have this question and it's landlord tenant related, but it's not really on topic for the class, save it for the end and I'll do my best to answer as many as whatever you got. And that plus the break point, the last bullet point there, gosh, sorry guys. I'd say with this class, I kept it scheduled at 2 hours. Again, kind of waiting until the 9th hour as tenant protections were expiring and everything, September 30th, as we'll talk about on the very next slide. Kept waiting for, news of them, at the state level, continuing or replacing those and whatnot. So I didn't want to shrink down the amount of time the class was scheduled for until, with just because of leaving room in there. With that said, they didn't replace anything. So more than likely, my guess is at most we'll probably be done in about an hour, I'm guessing. So we'll have plenty of time afterwards, let alone the 15 minutes. And since we'll more than likely be done, at an hour or so at most, obviously we won't need to worry about taking any breaks or anything. We'll just power through. Okay. Excuse me. So those of you that did pay the extra to get continuing education credit for your state of Oregon real estate agent, principal broker, or property manager license, go ahead and do a check-in now in the chat. If you've already done it, there's 2 of you that already done it. You don't need to repeat. We'll take that as your beginning class check-in. Cheryl and Betty, it looks like. But if anyone else hasn't done it yet, that you're expecting continuing education credits, go ahead. We need your name as it appears on the license, your license number, as well as broker affiliation. Just put that in the chat window for the beginning of class. And then if my assumptions are right and we end up at or under a full an hour, then we probably won't do any check-ins in the middle of the class. It'll just be one more at the end. So remember, name as it appears on the license number, and broker affiliation. All right. Try to clear my throat one more time and we will jump into it. And I see, let's see here. We did have, I think it was around somewhere between like 60 and 75 people pre-registered to be here today. So we may get some more trickling in. Also, for those of you that are already here, if you have connection issues or just life happens and you need to take off and miss part of the class, well, we can't give you continuing education credit. We are recording this, and we'll be sending out a link to a cloud file with the recordings after the class. I think typically we get them out, within a business day or 2 at most. Okay. All right. Let's hopefully that frog will not just stick there the whole time. I apologize. I've been on your side of it, and I know how annoying that can get. I promise I'll try to stifle it as much as I can. Okay. Eviction moratorium. So back in December of last year, SB 891 was signed into law, and basically what it meant, and this is, my guess is for the majority of you a review, but basically what this law put into place was that if a tenant applies for rent assistance anytime before June 30th of this year, then they can be protected from eviction for non-payment of rent until September 30th of this year, or until the point at which the app was actually, denied or canceled, or because they didn't qualify for some reason or something like that. And when they were protected, it was non-payment was defined as to include any debts owed to the landlord. So they're not just unpaid rent. So basically anything they owed the landlord, they were protected until the end of September. You couldn't charge any late fees, report them to consumer credit agencies, etc. Obviously, the tenant would have needed to provide evidence to the landlord, but they could have done that in any format of just, a picture of the computer screen or just email. Most of it was via email. I know at least within my company, the handful or so that applied for rent assistance, within a couple days after they reviewed the application and approved it for processing and whatnot, I actually got an email as the landlord from them saying, hey, they've applied, and confirming information. So, that counted if that was all we got. Excuse me. The other protection that this bill extended was the 10-day non-payment of rent notice all the way through the end of September as well, which was, if you didn't know, we'll talk about on the next slide. But originally, you could do as little as a 72-hour non-payment of rent notice when on the 8th of the month, when the tenant was at least 7 days late with their rent. It was for the temporary time as an additional tenant protection, and basically for the reason, which, whether we agree with the reason or not is, long past time for that debate. But the reason used was that, if tenants are going to be applying for rent relief and stuff, they need a little bit more time to be able to get that stuff straightened out and be able to start that process than just the minimum 72-hour period. So as part of the protection bill, they gave them a 10-day, made it a requirement. If your tenant is late on paying their rent, you had to give them a 10-day non-payment of rent notice, basically giving them 10 days to pay the rent that is late for that month instead of just the original 72 hours or 3 days. So if you are a fairly experienced landlord, then I could make the majority of this class extra short for you. One being basically all of the tenant protections, the short-term tenant protections that we're talking about here, the protection from, the non-payment of rent eviction, the protection of the 10-day requiring a 10-day notice instead of as little as a 72-hour notice for non-payment of rent. All of that did expire September 30th. So, less than a week ago. All of that did expire at the end of the day on September 30th. And so now, to make the class super short, if you really wanted to, technically it all goes back to exactly how it was prior to COVID. I will warn you, you don't, as we'll talk about here in a bit, you don't necessarily want to just jump to doing a non-payment of rent notice for, a super large balance that they accrued during that. And we'll talk about that here in a bit. So, but that is one thing that if you are a landlord, I know a lot of landlords, because it wasn't necessarily reported a ton. I'm sure there's a handful of you that that's the main thing that you want to know coming to this class. And that is the truth, that all of those temporary tenant protections did expire on September 30th. So just, less than a week ago. And everything as far as the rules, how you handle everything for non-payment, all that stuff goes back to how it was prior to. I will point out, landlords, don't just assume that this is the last we'll see of any of these. I know that the city of Portland, there's some, nothing official by any stretch of the imagination, nor has it been on like city council's agenda or anything like that. But there is scuttlebutt of people, tenant advocates pushing for behind the scenes some sort of, ongoing tenant protections. I know Eugene recently passed some of their first tenant protection laws. And, if Portland is any guide, I would imagine it's just, the beginning. So keep an eye out for stuff like that. One thing I know for sure, at the very least, will be debated. I have no idea if it'll actually be part of a bill that's voted on, but at the state level, for sure, it'll at least be debated and be part of the negotiations at the state level will be bringing the 10-day requirement, 10-day non-payment of notice, termination notice requirement back and making it permanent. No clue if that'll actually go through, or if it'll even get beyond just the debate level, if it'll even go up for a vote. So as of right now, all of these have expired. You do not have to abide by them anymore, but keep your ear out, just like any good landlord you always want to be anyway. There's a good chance we'll see at least the 10-day stuff come back at the next state legislative session. And if they don't get it, we might see it pop up for multiple state legislative sessions. We'll see. Let's see. Okay. And no questions yet, so we're good. So when I say everything goes back to how it was prior to COVID, COVID lasted a while. And so I'm sure some of you may just need a refresher, Or who knows, maybe COVID is what caused you to be to have to relocate job wise or something, decided not to sell that single family home and you became a landlord during it. So this is all brand new to you. Either way, wanted to not just end the class at, oh, by the way, all the protections are gone. So it goes back to how it was before. Obviously, people are going to need a refresher. And also, I'm sure there's a good handful of you that honestly do not know exactly what that means, as either you're new to it or possibly even you never had tenants you had to deal with, possibly having to evict for non-payment of rent prior to COVID. So this is new waters for you, so to speak. So non-payment of rent options, what you have is either a 144-hour notice or a 72-hour notice. Okay, and I'll review the 72-hour notice on the next slide, or just a draft of one, and go into a little more detail. But they basically have the two options. They all expire on the same day. Okay, so your 144-hour notice, you're allowed to serve it as early as the 5th of the month. And this is assuming your rent is due on the 1st. Okay, if your rent is due on the 11th, then we're talking about the 15th, right? So you do your math basically for 4 days after the initial due date, not counting that day. So if your rent is due on the 1st day of the month, then starting on the 5th of the month, you can serve a 144-hour notice stating, hey, you've got 144 hours, or really what that is, for those that aren't quick with the math, is 6 days. You have 6 days to go ahead and pay the rent that is currently late, or your residency, your right to occupy that unit is terminated. Your lease paperwork, your rental agreement is terminated. Or you have the option of serving a 72-hour notice on the 8th of the month. So it's 3 days less, but you're allowed to serve it 3 days later. So both of these notices expire on the 11th. So 72 hours is typically the most common one that people use. And with both of them, the tenant, they only need to pay rent that's due. They don't have to pay late fees and stuff like that. They only have to pay rent that's due in order to stay and to avoid eviction. Excuse me. For late fees, as well as when we talk about the larger rent balances that are due that have got accrued during the protection period, we'll use the delinquent debt termination, which we'll talk about here in just a couple slides. So this is what you're starting with October. I would suggest you using the 144, the 72-hour notice for October rent moving forward. If they're late, then either on the 5th, you can serve a 144, or on the 8th, you can serve a 72-hour notice. A couple of things to note. Why would you use a 144 notice? There's lots of landlords that they liked I wouldn't say lots, I would say they're in the minority, because the vast majority use the 72-hour, but of those that use the 144, there's plenty of them that use the 144 because they just want to give the tenant something official sooner. And so, rather than later, just kind of drive that point home of, hey, you need to do something. You've got, 6 days now, right? Within my company, our default is a 72-hour notice. We have used the 144, but when we use that is during, pre-COVID. I mean, now I think things are, probably, especially since the work volume has gone down significantly, since the protections and stuff have gone away and the funding has gone back down to pre-COVID levels. Rent relief that tenants can get, there's only so many options out there. There's lots of people don't always realize this. There's lots of nonprofits, like churches with a nonprofit arm and things like that, and nonprofits that are focused on housing and stuff that offer, emergency rent assistance, which is, not what we saw of emergency rent assistance in COVID of, months at a time, but literally like, we will give you the rent for this month if you can show us that, like, you lost your job, or Jimmy broke his leg and you have these big unexpected medical bills or something like that. So if that's the case, typically, and the tenant lets us know, hey, this is what happened, we're not going to be able to pay on time, and we're going to be applying for some emergency rent relief stuff through this organization, then majority of those organizations would actually need to see a non-payment of rent termination notice in order to start the processing as part of their application and qualification process. So in those cases, we would then offer a 144-hour notice because the organization is involved. Of course, if they can come up with the money and pay us the rent, and we want it, we want to make sure that happens. We'll give them that 144. That gives that organization then 6 days to do their processing of everything, to give them a little more time. So you can choose either one. Like I said, the typical standard of vast majority of landlords just wait until the 8th and serve that 72-hour notice. This is an example. Don't run off and use, go to that PDF of the class slides and copy this, because it is a outdated version. ORHA has updated these. That's why I feel comfortable using them on here. Also, they're a nonprofit organization. If you go to your local ORHA organization, or if you're in the Portland area, ROA.com, go to the form store. Whether you're a member or a non-member, you can purchase forms through the ORHA. Obviously, members get, I think it's like a 60% discount, something like that. But they have all been updated. This still works though for what I want to point out as far as the class is concerned and the pertinent information on there. So this is your standard 72-hour notice. Obviously, the 144-hour notice is a different notice, but the only difference is really that it's labeled a 144-hour notice. And as you can see on here, one of the things about their forms, they do kind of explain things. So it's a nice thing to be able to kind of walk through. It shows, for a 72-hour notice, you're informing the tenant that the rent is now at least 7 days past due. This is why you're be able to serve it on the 8th when your rent is due on the 1st. This is your 72-hour written notice to pay your past due rent, or your rental agreement will be terminated as provided by Oregon landlord tenant law, etc. Then their next spot, you put the amount of rent that they owe. So you don't include any late fees or anything like that. This is just the rent that you owe. Here you go. So Erling asks where you purchase those. I'll put the website link. ROA.com. So this is the association, nonprofit association that I run, where we do sell all these forms. With that said, I do need to make very, very important, I don't just do a commercial for them. In the Portland metro area, there's at least 3 of us main landlord support associations. Like there's a rental housing alliance of Oregon, there's multifamily Northwest, and I can't speak to the quality and validity of their forms. I'm not involved in their organization, but I have no reason to believe that their forms aren't just as legal as ORHA's. And I'm sure that, just like ORHA, they have, lawyers that review everything and whatnot. So if you're a member of them, look into them. My guess is they probably have forms you can use, and they're going to be very similar. At the very least, it's not going to be the same thing. There's nothing in the law about the formatting, but as far as the actual information on their stuff, it's going to be very similar. So these are the ones that I have access to. That's why I use them as my examples in the class. Okay, moving forward. And I put that, I put the link there in the chat. So amount of just the rent, you don't include late fees or anything else, because a non-payment of rent eviction is strictly about the actual rent itself. Next is how you serve this note, how you're going to serve this notice. So there's two ways of service that do not require any additional verbiage in your lease or rental agreement paperwork. That is, if you serve it personally, which is literally face-to-face, you hand the notice to them, or you serve it by standard first-class mail, which is literally just putting a stamp on it, put it in the mail, or you can take it down to the post office, at most get a certificate of mailing or receipt of mailing. You don't send it certified or signature required or anything like that. It has to be standard first-class mail. And if you do it that way, you have to add 3 days for mailing, and the day you put it in the mail doesn't count, right? So it essentially turns this, 72-hour or 3-day notice into basically a 6-day notice, not counting today. So if you want to be just safe, put in your notes, calculate 7 days. So add 4 days for mailing, just so if you accidentally count today, it's not if you accidentally count today, it doesn't mess up your dates, right? So you need to add at least 3 days for mailing. Today does not count. Then the third option that you do have, but only if it is actually stated in your lease paperwork, which if you use, any of the landlord support association around Portland's, any of our, leases, this is going to be in the fine print, right? But if you use a lease that has it in the fine print that allows what's called post and mail service of actual notice, then you are allowed to use this. If it is not in your lease paperwork, or you don't have a lease that exists, it's some tenants you inherited or something, then you're not allowed to post and mail. There has to be a rental agreement of some kind with this actually in this fine print. And what that is that's when you actually tape it to the main entrance of the dwelling. I recommend use painter's tape so it doesn't damage your door, and put, a piece of tape across all four corners just to make sure it stays up there. And then also at that same day, drop a copy of that same notice in the mail sent via standard first class mail. So if you do that post and mail, then you don't have to add any extra days for mailing, and you don't have to see them face to face to hand it to them in person. And so it remains just that 72-hour or 3-day notice. And then they also have a nice thing at the bottom to where, just as a reminder, unofficially, hey, also you do owe this is your total balance and whatnot. But keep in mind, if they show up with just enough to cover the exact amount that's due for past due rent, then that's enough to avoid eviction or termination. The other things to look out for, just for any notice you serve, easily of all the landlords that lose in court and their cases thrown out or dismissed, the last time I looked it up, the statistic I know is over 90%. I don't think it was over 95. I want to say it was like 91 or 92 point something percent of the cases that are lost are due to the landlord not filling something out properly. So keep in mind, this is, if you're going to end up evicting, this is going to turn in any notice that you use, it could end up in eviction. It's going to turn into actual evidence and an official notice that was served to the tenant. And so if their middle initial is J and you accidentally write A, that would get it dismissed out of court and make it invalid, so you have to start all over. If on the address of the unit where the tenant lives and you're serving the notice, you write in northeast instead of southeast, something like that, just a little typo, or you transpose a couple of the numbers in the address, something like that, that'll be enough to have it dismissed out of court, and you have to start all over. So make sure you always triple check your forms when you're filling these out. I literally mean it when I say triple check. Fill it out, right? Double check it by reading back through it, then walk away from it, do something else, get your mind off of it, come back, look at it one last time before you put it in the mail or post it or whatever you're doing. Let's see. Looks like we do have one question. Let's see. What if a landlord serves a 72-hour notice, then the nonprofit sends an affidavit that they will pay the rent, but nothing follows for a week? The landlord hasn't sent the nonprofit the 144. Any missed legal steps? Can the 144 notice be served with a delay of a week? So yeah. Okay. So I can answer your question a couple ways. Now that the tenant protections are lifted, the fact that they applied for rent assistance does not offer them any additional protection. So in this specific case, your question was about, I served the 72-hour non-payment of rent notice. And then the nonprofit the tenant is applying for rent assistance through sent you some sort of sworn affidavit saying, hey, yes, we are processing this and we're going to pay it. And then a week has gone by at that point. If that is the case, well, it's 100% up to you. Basically, all that really matters is that 72-hour notice. If you serve that 72-hour notice and those 3 days have come and gone, you haven't received any money, you have the right to file the eviction in court. And technically, even if the money does show up at that point, you have a right to refuse accepting that rent and moving forward with the eviction, because they didn't come up with the funds within the required 72 hours or 144, whichever one you serve. So it's 100% up to you. With that said, if they're basically taking care of the place, they're not committing other violations, and you have a sworn statement from a legitimate, nonprofit that is working on that and is going to pay you the rent for that, then I would say, my recommendation would be that you follow up with them first before doing anything official and filing your FED, your eviction case in court, and find out where they're at. Because If the money's going to show up pretty soon, you might be better off accepting that money this month and wait and see what happens next month. But that also depends on, how good or bad those tenants have been, whether, how the relationship has been, if you really want to, continue working with them. Excuse me, geez, as well as if, they're committing other violations and stuff like that too. But for the most part, if, they're all in all decent tenants, other than having trouble paying the rent this month, then, if you long as you can verify it, I would say, probably give them a little bit more time and see if it comes through. But as far as you being legally required to give them more time once they've applied, that requirement has expired as of September 30th. Delinquent landlord debt. Our delinquent debt, delinquent landlord debt. So this is, like I said, anything other than rent for sure. Okay. So whether that's late fees or maybe the tenant, clogged up the drain lines and you had to call a rooter company out and stuff. And so they owe you like $500 for that or something. That's typically what this bucket hole catches, so to speak. The main reason I included this, though, is that technically, so we've had these protections in place. There's plenty of you out there, one of them, myself included, that may still have tenants that have fairly large balances, right? 10, 20, 30, $50,000. And, stacked up, rent that they didn't pay for lots of months while they had all these protections, and they would, figure out a way to, apply for this program. And, if that, only paid out 1 or 2 months, it still bought them some time and then apply for another, blah, blah, blah. So technically, that is rent that is unpaid. And technically, by the letter of the law, the way that I interpret it or understand it, you should have a right to now do a 72-hour or 144-hour notice for all of their unpaid rent currently. With that said, I've ran this by a couple attorneys that specialize in representing landlords in the Portland metro area. So if you are joining us from other areas of Oregon, I would suggest before you take what I'm about to say as gospel and for sure how it is in your area, maybe double check with some landlords or your local landlord support association, or even better, a local landlord attorney that practices landlord tenant law in your area and have experience with your judges. But the advice that I got from both was, if you do have that debt, yes, technically by the letter of the law, it's rent, and in a way you should be able to include it on a short term, 72 or 144-hour notice. They both, without even really thinking about it, strongly recommended not handling it that way and actually handling it as your generic violation for delinquent debt. So even if you don't have a lease in place, which, it is of course better if you've got a lease in place with debt information, sometimes it gives you the right to charge some interest or, possibly, and charge late fees, things like that. But even if you don't, in landlord tenant law, ORS chapter 90 at the state level, I couldn't tell you the exact chapter number or section number, but I know it's somewhere right about the middle. There's a whole section labeled tenant responsibilities. And to paraphrase, I'm sure I'm not quoting that, but to paraphrase, essentially one of those responsibilities is to pay all debts owed to their landlord. So these protections have ran out. They definitely owe you that money, and there is nothing additional they can do to get additional legal protection for longer. So the lawyers that I've talked to have strongly recommended not using the 72 or 144, just because even though the letter of the law may state it one way, that doesn't necessarily mean that's how judges in your area are going to be citing and whatnot. And they said, to give yourself the absolute best chance of not going down that road and then having it possibly dismissed by a judge, and then having the choice of, well, do I start over with the 1430 termination notice, or do I try to appeal this and sink more money into this specific case and whatnot. Their recommendation is to do a standard termination 1430 like you would do for any just kind of non-renter delinquent debt that a tenant owes to a landlord. So first thing you would want to do is, and technically you shouldn't have to do this step, but I will tell you I think we only have one. No, they're being evicted for another for cause reason. I'm pretty sure, I feel like we would have one, but the way we handle it would be to actually, you want to give them a reasonable time to pay. If we're talking about this large lump sum, then lots of management companies, and for really any debt owed, state law just says it has to be a reasonable amount of time. There's plenty that are as low as 10 days. If you get the ORHA form for citing for violation for debt, or for like the move out and billing your tenant, they have it set at 10 days. So you can absolutely do it as little as that. Within my company, for our standard non-rent debts, like the drain being cleared or something, or billing for utilities, we would give them 30 days as our policy. But just make sure whichever amount it is, it can be considered reasonable. Like I said, the lowest I've seen that has been 10 days. And so I wouldn't suggest going below that. But bill them for what it is that they owe, saying, hey, you owe this amount of money from all these dates. The protections ran out September 30th. You've got, 10 days, 15 days, 20, 30 days, whatever it is you choose to pay that. Ask yourself if you're willing to accept a payment plan. If they do not pay that amount in the amount of time you gave them, then you are, or they set up a payment plan, but then they violate it. Then I would jump to your standard termination notice, which is what's called a 1430, which is I call it a 1430. Lots of, depending on where you're buying your forms, they may call it, a termination with cause or termination for cause, something like that. I refer to it as 1430 because standard practice with it is, you violated this, you're violated either your tenant responsibilities by Oregon law or your lease by not paying this debt. I'm basically saying you've got 14 days to correct the violation, or on the 30th day, your residency, your right to occupy is terminated. And so we would give them, you've got 14 days to come up with this balance due, or if we're willing to accept a payment plan, that there's nothing, to be very clear, as a landlord, it's 100% up to you whether or not you accept a payment plan in cases like this. So again, it kind of goes back to, do you feel like they can be a good tenant that gets back on track, or are you way beyond that and really just want to get either they can come up with all the money or they can't, it's up to you. But basically give them 14 days to correct the issue, which is paying that amount, possibly coming up, agreeing to a payment plan that you're willing to agree to, whatever it is that you can come up with for them to solve the issue. If they don't, then by the 30th time, or by the 30th day, so it's not 30 days after the 14, it's you have 14 days to fix it, or 16 days later on the 30th day, the residency is terminated on the 31st day or the day after that. The next day your local courts are open, you're allowed to file your FED eviction with the county court. So if you have that large balance, and that's one of the main reasons you're here today, this is the most recommended way to handle it. Technically, you should be allowed to skip the part where you bill them, but it's recommended that you go ahead and handle it that way and bill them, give them at least 10 days to come up with it. Then they don't, then you serve the violation notice stating, hey, you got 14 days now to come up with it or reach a payment plan if you're willing to, or on the 30th day move out. And then if all that time passes, you've got no money, they haven't moved out, then you can proceed with a for cause eviction. Let's see, we're going to question here. What would your recommendation in regards to waiting for payment from Oregon Rental Assistance? The tenant applied after 6/30 and has been over 2 months. We have served a 10-day notice that payment is due by 10/6. Fine. Yeah. You're handling it how I would suggest. Absolutely. I kind of exactly how I would suggest right here. And again, it's up to you. If Oregon Rental Assistance or some organization is processing it, then yes, as a landlord, you have a right to just move forward with eviction if that money hasn't shown up by the time they had. or you can give them more time, and so I would suggest, it's obviously a case by case basis. If you've got those, what majority of tenants are, which of, good, decent tenants that just having trouble paying their rent. If they have if they're caught up, you would be happy to keep them as a tenant, then contact the organization, see how close they are. If you're able to get some answers, I know some of them can get backlog and aren't the best at communication. But as far as the law is concerned, at this point, since September 30th come and gone, you should have the right to move forward with non-payment of rent at this point. This is just an example form of a promissory note. If you did accept some sort of payment plan, how that would look. Pretty straightforward. It's just contract law. It's not landlord tenant law that regulates this. It's just contract law. So it's really, it's the same law that regulates you selling your own car to a private party. Like literally you can write out the sales contract and stuff on the back of a napkin if you wanted to. But this is just kind of an example of that form. Is basically just lines out, who the tenants are, where they're located, who the landlord is, what amount is owed, and then the payment plan of how many payments, exact due date and exact amounts, and sometimes can't always divide evenly and whatnot. And so so pretty straightforward. This is that termination with cause, the one that I call a 1430. Again, pretty straightforward. I've already talked to you about the importance of getting the name right and the address, so I'm not going to go over that again with you. Then the three different types of service, what that means. Don't forget, if you do just standard first class mail, you got to add that 3 days for mailing, and you don't count the day you put it in the mail. On here, you calculate out 30 days later, or if you're doing it by standard mail, 34 days later, your tenancy will terminate on this date. That's that 30. And then the next section is explaining what they did what am I trying to say? What they did as a violation, what violation committed. So in this case, what I'm assuming most of you are here for is they owe you a big chunk of money and they didn't pay it by the time it was due, right? The violation can be cured, and the cure date is by this date. In there, that's where you put what they can do, or 14 days later, right? If you're mailing it, maybe call it 17. So you put that date in there, and then on the next section, what it is they can do to rectify it. So in this situation, it's pay the total amount due, or work out a payment plan. If you're willing to work out a payment plan, you don't have to give them that option. And then obviously it says, yeah, if you cure it, great, you can stay, no harm, no foul. If they don't cure it in the 14 days, then it also, in that fine print, basically it says that you have to be moved out on the 30th day, and if you're not, have the right to move forward with an FED eviction. Let's see here. I think we had a question over here. I've had many great renters and never needed to kick someone out or evict. Which is, one thing I will tell you, and I'm not sure if this is where we're going with this question or not, but one thing I will say is, I look at tenants, they are just like any other group, whether it's landlords or pick literally any way to say this is a group of people. There's a small percentage that are quote unquote bad apples and are the ones that we have to have all these laws for. Obviously, sometimes depending on socioeconomic stuff and just economics and whatnot, lots of times, or things like COVID and whatnot, sometimes it makes the scale tip a little bit to where maybe you have a higher percentage that aren't able to follow and stuff. But by and large, typically most are. I mean, for my own tenants, it's very rare. If we've done a screening, we were established and started the relationship with the tenant, it's very rare that we have to actually do a full-fledged eviction. So I would agree with that. It's very possible if you're a smaller, landlord, for you to be a landlord for a long period of time and not have to deal with, evicting a tenant. So I would totally buy that. Let's see here, but my most recent one doesn't clean, sure, at all. Smokes inside, which I'm assuming, since you have a problem with that, that is a violation, and violates the agreement in many ways. But he pays his rent and doesn't want to move. With COVID restrictions, is it possible to give an eviction? My second question is, so the short answer is yes. Yeah, I mean, and this was actually never protected for those types of violations, like smoking inside and refusing to change it. Let's see here, whatever the other ones were. If those are violations, you actually, because of COVID, they were never protected from eviction. That's actually something, as long as you're given them proper violation notices and whatnot, and given the ability to correct it or stop, then you are able to earn your right to evict, even if they are paying their rent on time. Doesn't matter if they're committing violations of landlord tenant law or your lease, then it is something you can cite them for. Let's see here, but he pays his rent and doesn't want to move with commercial. Okay, so yes, you can do that. Second question. Next year, I hear the police will not be enforcing tenant evictions due to a new law. Do you know about this? And is it true? After this class, who can speak to ask a follow-up question? Oh yeah, you can always ask a follow-up question after the class. No, I haven't heard that as any kind of new law stating, making it so that police would not enforce evictions. I mean, the way that I understand it, that would be in violation of state law. So it would have to be something that would be changed at the state level. I mean, yeah. So actually, the short answer, just to make it easy, is no, I haven't heard of that. Who knows what they might come up with. I definitely won't go out on a limb and say, oh, for sure it's not possible that'll ever happen. But I would think it would be a stretch. And as of right now, I haven't heard anything. So, okay. Let's jump on. I believe this is kind of the last one that might affect some of you with those things expiring. One of the other pieces of protection that had existed was that if you had, let's say you had a 2-bedroom rental and you had an occupancy limit of 4 people or possibly 5. Typically, as a landlord, you're allowed to choose one of the other 2 people per bedroom or 2 people per bedroom plus 1, right? Whoops. Sorry about that. It was kind of loud. Spilled my water, but it is just water, so I'm fine powering through real quick. It's not staining anything. So anyways, so one of the protections, because the reason for it, again, we don't need to debate that. It doesn't really matter the reason, because it's already been passed and now expired. But the reason for it was that we want this protection so that landlords cannot enforce their occupancy limit during these temporary COVID tenant protections, because of that might be something that helps avoid certain homelessness if other people who aren't able to pay their rent because of COVID get kicked out and have to have a place to live, and them as a friend or family member allow them to move in. That was the whole reasoning behind it. That has also since expired. So I want to do a quick review of just, hey, if you do have those where they're still there, you have unauthorized guests in your unit, what you would want to do about that, or what you're able to do about that. I mean, the first question is, are you okay with them staying? I mean, you may have been, forced to have these people living there for, a month, 2 months, could be 6 months, who knows? How's it been going? I'm assuming do an inspection. Is there noticeable wear and tear or extra damage? Have they been respectful to their neighbors? All that stuff. Are you okay with them staying? Because if you are okay with them staying, then you can go ahead and have them, if you want to live there, you can have them fill out an application, do a full screening, approve them, add them to the lease if you want, or extend their temporary occupant agreement for longer or something like that. So that's the first thing, is if you're okay with it, you can be okay with it and work it out. But you can also require that they are screened and approved, and they're not pose a threat to the neighbors or something like that. Let's see here. For short-term guests, use the registration form. I probably should have removed that for this class, because I copied this from a different class. For specific to what we're talking about today, probably not talking about a short-term guest. If they're temporarily moved in, so yeah, so if you want to extend this, then you can screen them if you want and just use a temporary occupancy agreement, or if you want, you can use an opportunity to update all the lease paperwork and have them added to the actual leases as full-fledged tenants. Either way, if let's see here, if use temporary occupancy form. Oh, If you just absolutely don't want them there, so skip all this, you don't want them there, or you would be okay with them there if they were willing to fill out the application, get screened so you can approve them and do the paperwork, and they're refusing, whether it's your tenants are refusing or they're refusing, either way. If that is the case, or like I said, you just don't want them there at all, that at that point it's a violation for unauthorized guests, and you can serve that 1430 or termination for cause notice, giving them, say, hey, you've got 14 days for these unauthorized guests to be gone, or on the 30th day, your residency and rental agreement is terminated, and after that, you're able to file for eviction. Let's see here. I got a couple questions. Does smoking odors qualify as proof that the tenant is smoking inside a rental, or do you need to see them doing it? That's tough. It is a he said, she said. If you go there, just odors you smelled. What I always recommend is, if you can get, a neighbor to come into court, be willing to come into court and testify that, hey, yeah, I've seen them, smoking through the window or something like that. Next to that, the best you can do that I've heard people use is having a third party. So hire a maintenance person or contractor to go in and inspect the furnace or the bathroom sink or something, and tell them, hey, on your invoice to you and in your job notes, please include a description of anything you happen to smell if you notice anything. And so that can work. But yeah, you are right to be concerned and possibly look for other violations if the only proof of smoking you have is that you personally, as the landlord, has smelled it during one of your inspections, because you can't prove that in court. And if the tenant just shows up and says, nope, I never did, they're just lying, then it's your word against theirs. And to be perfectly honest, I don't know how it will go. It depends on the judge you've got that day, quite honestly. With that said, you could serve the violation termination notice for the smoking. And since they know they were smoking in there, that might be enough to scare them into working out an agreement to peacefully just move and avoid an eviction on their record. So, just because it is your word against theirs doesn't mean it can't be successful. Just know that, yes, you're right to be concerned. Proving a smell is definitely on the harder end of being able to make sure an eviction sticks. Let's see here. Regarding previous question where they gave the 10-day notice, from my reading online, you can't give a 10-day notice for failure to pay rent. Am I mistaken with this? So yeah, so you can give a 72, as we talked about at the beginning of this class, right? You can now give, it used to be you're required to do a 10-day notice for non-payment of rent. September 30th, that expired. That was one of the temporary protections. You can now give a 72 or a 144-hour notice. One thing I will tell you, though, is so the earliest you can serve the 72 is on the 8th of the month if the rent is due on the 1st, or the 144 is on the 5th of the month if the rent is due on the 1st. Both expire on the 11th. With that said, with the way the laws are written, it's a minimum of that amount of time. So technically, if you wanted to, as a landlord, you just decided, hey, you know what, I agree with that, I would like to go ahead and still serve a 10-day notice. You can serve a 10-day notice for non-payment of rent. Just the earliest you'd be able to serve it would be on the 5th, where if you're essentially serving a 144-hour notice, you're just giving them more than the minimum required 144. So as early as the 5th, you could totally serve a 10-day non-payment of rent notice if you wanted to, which really, like I said, you'd be serving a 144 notice. But the expiration date on it, the amount of time you're giving them to pay rent, is 10 days later. There's nothing in the law that says you are not allowed to give the tenant more time. So yeah, you'd be perfectly fine doing that. My guess is what you're probably thinking of is the 10-day termination for the 10-day repeat violation termination notice, which isn't rent related. It's for any other types of notices. So my guess is that's probably where I got what you're thinking of. But let's see here. Hank says, why not allow extra tenants for extra money? That gets tricky. I have heard of landlords charging a, hey, my occupancy limit is this, over this amount, it's an extra blank dollars per month per person, right? I have heard of that happening. I wouldn't recommend it, though. And I would imagine any landlord attorney you run it by would say it's definitely not recommended, because they're part of like that fair housing class I teach. We cover this. Part of the protected classes is your familial status, which is basically the makeup of your household. Okay, and which basically says it is not legal to treat an occupant, someone differently because of the makeup of their household, which that's where the occupancy limit standards and for landlords and stuff, that's where all that kind of falls into as far as fair housing goes. So by charging them extra for simply having more people, it's not a big leap to see how that could be construed as a violation of fair housing based and discrimination based on familial status. So I wouldn't recommend doing that. I would recommend if you have extra people, it's just you are either okay with it or you're not. And also know as a landlord, if the amount is over 2 people per bedroom, or if you chose to go more conservative, 2 people per bedroom plus 1, if it's over whatever your policy is, then you're allowed to cite them for having unauthorized guests, and it's a violation. With that said, again, it's up to you. I mean, if they've got, 1 or 2 people over your limit, and in your opinion, maybe you can't charge extra rent, but in your mind, it's, well, that's a couple extra adults that work and have a job. So my percentage chance of them being able to continue to pay rent and not run into financial issues if they got multiple people employed goes up. And so your risk of them not being able to pay rent goes down. Maybe you're okay with the perceived, extra wear and tear by having more bodies in there. I don't know. But yeah, I wouldn't recommend charging extra just based on the number of occupants. I would just make it you're qualified or you're not, and here's my cutoff, right? All right. Our tenant owes money. I believe our tenant has moved out. Okay, so all right, we're getting into ones I should be saving these for the end. Sorry, guys. Let me power through the next handful of slides to finish up with unauthorized guests, and that's really the last one we have. Well, then I'll close out the class. Then I'll jump back to just answering any landlord tenant related questions. Okay, so we talked about unauthorized guests, what to do. Guest registration, if it's short term, that's where this applies. If you have like an apartment complex, you need to know who's coming and going and going to be there for, even if it's just for a few days. It's a form you can use. This is the temporary occupant agreement. If you're going to be okay with them staying, but you don't want to necessarily make them a full-fledged tenant, you can go ahead and have them plus your tenants all fill out and sign a temporary occupant agreement, which basically just means that they're allowed to continue living there until such and such date, whenever you say that it's going to end. And but it's at the sole discretion of the tenant who is actually on the lease. So they have the power to cancel this if they choose to. And if the temporary occupant is committing anything that would be a violation of the lease or landlord tenant law, then it reflects just as though your tenant who is on the lease had done them themselves. So it gives you kind of, a little more authority there. It is just, a quick option if it is going to be temporary. And then, of course, the notice of termination with cause of the 1430. So we already did that. Oh, sorry, Alicia. I saw that Patrick was, and so I didn't even think to look for you. So there you go. Got you upgraded. Okay. Let's see. So notice of termination with cause. Landlord compensation fund. So this keeps going back and forth. It's supposed the official state landlord compensation fund is supposed to be shut down, but there seems to still be certain organizations around the state that still has some money. Portland metro area, as far as I can tell, is basically any money that is left is being already earmarked for applications that have already been put in and stuff, and to where this is basically ended. But I do know the city of Portland is debating, like the rental services committee level. We are currently talking about, I think actually at the next rental services meeting, we are actually talking about a recommendation to go to city council that includes, continuing some sort of rent relief program, and within that allowing landlords to be able to apply for it directly, not making it to where only tenants can apply. So I just want to keep this on here as just a review that, hey, it's worth it if you have a tenant that has that big balance that was accrued during the COVID time. it is worth it to at least do some research there locally in your area. There's a good chance there is still some money available to you. But like I said, technically this official one at the state level has since they have announced that they've closed that down. But like I said, keep an eye out for it. It's the main reason I just included this in here, just to make sure as a reminder to say, hey, keep an eye out, look, do the research. Don't just assume it's for sure gone. I know I actually just recently got one of the tenant rent relief payments, I think last Thursday or something. So I know there's still, even though the protections and everything just canceled at the end or expired at the end of September, I know there is stuff that there's still funds being paid out, and they are still working on that type of stuff. If you do have a tenant that has issues, still worth giving them this information, because just because the tenant protections and the state-based rent relief program and stuff and that stuff is all being shut down, these are resources that existed pre-COVID. 211 info is something that any tenant all around Oregon can go to and find out what are all of the different, not just state funded, but I believe even some of the local like nonprofits that help tenants and stuff. What are all of the possible options for them? And so they can go down that road of seeing if they qualify. If you've got, obviously, if you got a tenant that owes you 50 grand from COVID, that's one thing. But, as I said prior to COVID, when we were talking about such big expenses, if you've got a tenant that they're honest with you, they're being responsible, they're letting you know ahead of time, hey, such and such happened. I don't know if I'm going to be able to pay rent this coming month. And they're good tenants, hey, if this wasn't going on, I'd like to be able to keep them. Give this info to them. Try to help them out. Try to help them find, funds there locally if you can. And with how steep of a cliff the funding has gone off on rent relief for tenants in Oregon, since all of that was, funded because of COVID and everything. This is going to be a hot topic in all of the small local areas, probably as well as the state level, for I would say at least the next year or so. So if there's not something now, keep your ear to kind of the local news grindstone, so to speak, and odds are, at the very least, it'll be talked about. Who knows? Of course, there's lots of things that goes into whether or not new programs are created. Also, some of this, a couple of things the city always wants me to talk about. Let you guys know it is not required within the city of Portland by any means yet, but they do fund what's called a mediation, landlord tenant mediation pilot project, to where it should, I believe, if I remember right, it should be free for you guys to use. And contact them. They will provide a mediator to try and work things out between you and a tenant before having to go through the actual eviction process and spending all that money. So if you think it's something where you might be able to work it out, and if hey, if we just had a third party to where maybe it wasn't so emotionally charged and whatnot, I encourage you to use them. I know there's areas like down in Salem, Marion County, they actually, as part of the eviction process, require you to at least attempt to work something out in mediation. And I've had very good success with it. So I can't say I've actually used Resolution Northwest yet. I haven't had a reason to yet, so I can't speak to their program specifically. But the city of Portland is funding this to see how it goes. And so if you think your situation could be helped by it, I encourage you to use it so they can get those statistics. And if it goes great and things work out, awesome. Maybe it's something the city will look at, putting some more funding into to help landlords and tenants work out their differences or peaceful move outs, things like that, without the added expense of evictions and tenants having evictions haunting them as they move forward, trying to rent other stuff on the record and whatnot. So definitely look into it. This flyer is also in your shared materials folder. So if you didn't have time to write everything down, don't worry, you have a copy of it. Also, if you have a rental property within the city limits of Portland, you should have this information saved, especially like the rental services help desk. Lots of times there can be some gray area. Of course, they pay for classes like these, and sometimes you need a quicker answer. Of course, I recommend join a local landlord support association. But as part of what you guys are paying for by having rentals in the city of Portland and paying that $60 per door registration fee every year, part of what that staffs and pays for is the rental service help desk. I think they're only open like 3 days a week or 4 days a week, so they're not always super quick, but email. If you got a gray area and you're like, hey, how does this apply? You know, what, blah, blah, blah. They can't give you official legal advice, but it's a, you know, good area to be able to get some answers if you need them. Oh, nope, that's my line. Okay, so I will go ahead and answer any questions that are landlord tenant related, of course, but first I want to close things out. If you guys needed continuing education credits before you leave, please do a end of class check-in in the chat for me. That is your name as it appears on your license number, and your broker affiliation. If you have any general landlord tenant related questions that you want me to address here in a few minutes, go ahead and start typing those in the Q&A section now. Again, thank you for attending. It's put on by rpmeducation.org. So visit rpmeducation.org to see all the future free classes paid for by the city of Portland. Paid for by the city of Portland, as well as we have, gosh, I think probably 4+, I don't know, probably at least 4 other classes every month that you'd have to pay for because the city of Portland isn't paying for it, but I have a lot of options on there. As well as, of course, join your local landlord support association if you haven't already. You know, make sure you are doing those check-ins. I know there's a few of you that wanted to do check-ins there for your continuing education credits. So make sure you do those check-ins in chat. For those of you that don't want to stick around and learn from questions that other people are asking, or don't have questions yourself, you are welcome to take off, and you are officially about 45 minutes early. So you've got 45 minutes on your calendar unspoken for. Up to you how you use it. Otherwise, I will go ahead and start on these questions. Let's see here. Sandy asks, for tenants that owe $10,000 plus, what is the first notice we should give, and how much? Well, that's what I talked about, Sandy, when I was talking about the delinquent tenant debts. Right? Give them a reasonable, you have to bill them, right? Give them a reasonable amount of time to pay. And that's where I talked about, it could be 10 days, could be 30 days. Within my company, I do 30. But many places do 10 days, as little as 10. Then if they don't pay it, then it counts as a violation of landlord tenant law, and you can serve a for cause termination notice, or what I call 1430, where they have 14 more days to pay it or work out a payment plan if you're willing to accept a payment plan. Or on the 30th day, their residency and right to occupy is terminated, and you can then start the process of officially evicting if they didn't pay it within the 14 and they didn't move out within the 30. Let's see here. All right. Okay, so let's get a couple more questions here. Our tenant owes money. I believe our tenant has moved out. They do not respond. Can I enter the property? What should I do to get the possession if they have in fact left? Okay, so if you believe a tenant has moved out, but they haven't told you that, they haven't given you keys, that would be about the only ways, for the most part, the only ways that you would know outside of inspecting. You can't just go in. You need to actually serve a 24-hour notice of entry. Okay, if you just mail it, then that turns it into, you know, a 4-day notice. But you can, if your lease allows, you can post and mail. Obviously, if they're not there, you can't serve it personally. But if your lease allows for it, you can post and mail, post it on the door, and then put it in the mail that same day. Gives you at least 24 hours later, then you can go in and do an inspection. It has to, the law isn't specific of, hey, if this is gone, then you count it as moved out. Now, if there's keys on the counter and a note that says we've moved out, then yes, your inspecting is done. You can count them as they've moved. And you can change the locks if you want, whatever, they're gone. Or the other part of it is you have to look at it as what would a reasonable person, if you're standing in front of a judge and said, this is what I did or didn't see, would the judge think a reasonable person would agree that, yes, they've moved out? So if you go through and all the living room furniture is gone, there's no beds left, all the beds are gone, you know, then you can probably, you know, send a bunch of pictures just in case you might need to prove it later, but you can probably assume, yeah, they've moved out, right? But if some of that stuff is there, then you may need to go down the evicting for non-payment of rent. But if it looks like to any reasonable person that they are gone, If they're gone, then you're able to change locks, and there it counts as they have relinquished their right to occupy, and you're allowed to change, have them, they're locked out and count them as gone. So it just depends. But yes, you can't just go in. That's the main part of your question. You can't just go in. You do need to actually serve a notice of entry if you don't have solid verification they have moved. Sandy asks, I've been using Form 14 past due rent reminder. Is that, as it seems, a friendly reminder, or just where does that form fit in? Form 14. Is that one of the ones I talked about? I don't think it was it? Let me look at something. That's 4. Which one is 14? I definitely don't know them by number. 31. Just looking here, see if there's one of the ones I had. No. All right. I'm not sure 14, but based on your question, it's some sort of past due rent reminder. I mean, you can send them a reminder anytime you want that they owe rent and hey, your rent is due. You could be sending them reminders. Oh, I think that's kind of like the soft reminder. It says, hey, your rent is reminding you that you have rent due, but because of the tenant protections, we can't really enforce anything or something like that. That's fine. You know, you can send them reminders all you want. As far as being able to enforce that you have to pay it by this amount of time, then if you want to enforce, you know, you have to pay it by this amount of time and get the right to evict, then of course you have to use the proper forms for what am I trying to say? For evicting for non-payment of rent, that's 72 or 44 or sorry, 72 or 144 hour notice, non-payment of rent notice. All right. Let's see here. Anonymous. All right. My former tenant moved out without paying 2 months rent in August and September 2020. He and I signed a promissory repayment plan that he was supposed to pay the 2 months past due rent by January of 2021. But he never paid $1. I know where he moved to, and I hope he still lives there. He refused to sign the form for landlord rent reimbursement program, and I got $0 from that fund. Got it. What are my remedies at this point to get him to pay? Where can I report his delinquent account with us of $4,000? So he moved out in 2020. That was one thing with people that moved out and they had debts accrued during that COVID protection time. They had a lot of protections and stuff. What I personally do with delinquent debts, tenants that have moved out, we'll spend 30 days trying to collect, and if we can't, I automatically just turn it over to collection agency. I assume the money's gone. With a professional collection agency, typically have about a 20-25% collection rate with tenants. And so that would be my recommendation. If you want to handle it yourself, you need to actually, officially, I mean, the quick overview, of course, do some research to make sure you're getting all the verbiage and everything right on the forms you use. But a quick overview is you have to make sure you officially bill them saying, hey, you owe this, or I'm sending you to collections if you haven't already. We're going to, take you to small claims court. Then you sue them in small claims court and whatnot, and try to get your judgment. One thing, because of all those protections, delaying things, I think you'll be okay. But do know that there's a lot of back and forth on delaying the statute of limitations for a landlord and a tenant to sue each other, which normally is just 1 year, which means if you haven't taken the small claims court yet, technically you no longer have the right to collect that money. But because of all those protections that said you can't take them to small claims court, you can't issue, late fees and report them to collection agencies. They extended the time frame of calculating, that statute of limitations. So I believe you're still okay. If you were my client, one of my property management clients, I would strongly recommend that you just let me turn the file over to a collection agency and At the very least, that'll get it without any extra cost for you. That'll get it onto all 3 credit bureau credit reports so that future landlords will see that they owe a previous landlord money. You might, like I said, you got about a 1 in 4 or 1 in 5 chance of actually seeing any money. And then of course the collection agency will take anywhere from 20 to 50% or so of what they collect. So you might see some money, but honestly, I would count it as gone, but get it over to a collection agency. So that way, if they're able to pursue things, maybe they got a regular job and, the collection agency is able to, garnish their wages and stuff. All right. So for back rent from COVID hardship that was filed after 6/30, landlord has to give a 72-hour notice first, then a 14/30. No. So technically, by the letter of the law, you should be allowed to give a 72-hour, 144-hour notice and just handle it like normal unpaid rent. As I stated, though, the landlord-tenant law practicing attorneys that I talked to both strongly recommended, though, that you don't handle it that way, and you actually handle it as just a delinquent debt, where you give them a reasonable amount of time to pay what they owe you, when it's 10 grand, 50 grand, whatever it is. And that has to be at least 10 days, could be 30 days, somewhere in between, but you give them a reasonable amount of time to pay. Then if they don't, then you serve the 14/30 of, which is, okay, you're now in violation, and either you make do good on the debt within 14 days, or you move out by 30. And if you don't do either one, now you can file the FAD eviction and move forward. Again, though, double check with the landlord attorney in your area, because that's also something I'm finding can definitely change from one jurisdiction to another, or one judge or another. So unfortunately, I can only do as good and be as consistent on my answers as the actual system is. And as we all know, the actual system isn't always 100% consistent across the board. Let's see here. So to follow up on the 24-hour notice of entry earlier, what would I put as a reason for entry? Inspection? Yeah, inspection. Yeah, that's all you got to put. Of course, RHA, if you go to portlandarearoa.com, on our forum store, we've got a notice of entry. Just check a box of we're entering to inspect. That's all you need to do. Yep. I mean, in other, you can put to inspect to verify that tenant is still occupying. If you want to put that specific, you can. As far as I'm aware, you wouldn't be in violation or risking anything. But if it was me, I would probably just use an official form, keep it nice and simple, just check the box that says to inspect, and serve that and call it good. So I think either way, you're fine, though. Do you know of any good collection agencies that handles Oregon rents? I called around, and many California collection agencies dropped collecting past due rent in Oregon due to some Oregon new regulations. Yeah, you do have to call around. Sometimes national ones will have issues with Oregon protection laws, but also some will have issues where there's collection agencies that, because tenant debts have the lowest percentage chance of collecting of any delinquent debt that they deal with. There's collection agencies out there that it has nothing to do with Oregon. They just won't take tenant debts, period. Or if they do take them, they have to be over, at least a few grand to make it worth their time or whatever. So you do have to do your own research. I will tell you, to be perfectly honest, I can't remember the exact name of the national company we use because it's actually built into our property management software. So and the main reason we use it is just click a few buttons, it goes right to them. We know they'll take it for us. I can almost guarantee if you do a quick Google search for collection agencies in Oregon, that you'll find at least a couple. I apologize, I can't remember their names, but I know when I used to use local collection agencies, and this was, gosh, eight years ago, probably. I know there's one based in the Salem-Keizer area, and I know there's one based over in the Central Oregon Bend area that are bigger ones for just kind of state of Oregon specific. So that's what I would probably, if it were me, I would start there, is doing some Google searching for collection agency based in Oregon, and then start contacting them, and understand you may still get told no, either because of the amount or possibly just simply, like I said, they don't take tenant debts. So I apologize, I can't tell you, oh yeah, call this one or this one, that one, or the other one. Unfortunately, and a product of my environment, It's kind of, it's built into the system that we use. And so I just don't know right off the top of my head, but I do know for sure there are multiple ones that are actually their whole organization is located here within the state of Oregon. So I would be very surprised if when you contact those ones that you would get told no because it's an Oregon debt, right? So at least I point you in the right direction. Didn't really answer your question, but at least point you in the right direction. All right, looks like we got one more question here. The statute of limitations, 1 year to sue a tenant and landlord, vice versa. Is it postponed due to COVID rent moratorium by all this extra time? How can I find out if I can still take this tenant to small claims court? Yes, it was. So it was postponed as part of it. Man, let me check something really quick here. Actually, you know what? That's what I'll do, Alyssa, because that's going to be easier for everybody, and I can make sure that I don't get something. I don't accidentally click the wrong link or something like that. So what I will do. So Delano asks it in here. Let's see here. Contact. First follow-up questions there. But yeah, Alyssa, so for your question, I know it was postponed. I can't right off the top of my head tell you the specific dates, and I feel bad. It's definitely something I should have researched and had ready for you guys. So what I'm going to do on that specific question, on the specifically the statute of limitations, the time to collect debts, how long that was delayed because of all the COVID restrictions, everything. My understanding is it was basically, it's like that amount of time where you weren't allowed to, that all expired at the end of September 30th if the tenant got their protections ended. But then of course, if your tenant moved out, I don't know. So I will find that out. I would imagine by the end of the day today, worst case scenario be tomorrow morning, but by end of the day today, and I will give it to our admin team to go ahead and email out the specific dates on that and how that's addressed and all the information on that to everyone that signed up for this class. And actually, my guess, because they're going to be sending out the link for the recording as well. My guess is they'll probably just wait and we'll go ahead and include that information as just kind of an overall class follow-up that has the video recording and the answer to that. So I apologize as you guys are asking that. I'm like, I know it was delayed. So I know, if your tenant has, a 2-year-old debt that started in COVID, that you're not totally screwed, but I should absolutely have the exact dates for you. So I will get that, I promise, and get that out to you. No, so last question, do you know whether the state program, the rent assistance program, is still processing applications, or are they done as of September 30th? They are supposed to be done. And supposedly we should see that website actually be completely deactivated. If it's not already by now, I believe it's by sometime in mid-October, something like that, when they're anticipating at least having everything paid out, because they won't want to, I don't think they want to take it down while people may still need to log in and check on the progress of stuff they already have in place. So as far as I'm aware, they are not still processing applications. But like I said before, if you go, to that, what was it, 411 info, right? Or info 411 or 211, sorry, 211info.org. It's a nice color. It should be able to find out, give it what your area is, and get an idea if there happens to be anything that's available that maybe vast majority of those things, 99+%, are going to be the tenant has to apply for them. So, as a landlord, you may just be stuck at this point of you can try to collect and send them to collections and go that route. So, but like I said, I will look up the statute of limitations. I'll email that out to everybody. Make sure they have those exact dates and how that looks. Other than that, thank you everyone for attending. I really appreciate it. And if you liked what we did, like the class, do a quick Google search for rpmeducation.org. And on the right-hand side, you'll see a Google business page. Go ahead and click the add review there and get and leave us a 5-star review. That's what I'm trying to say. Okay, Alyssa snuck in one follow-up to her question. I'll answer that, then I am signing off. I applied for landlord reimbursement fund and never heard back. What should I do? Any chance of them paying any dollars? Do you know if they still have any money left? The honest answer, Alyssa, is I don't know. I know I just received a $5,250 rent relief check on Thursday of last week. And so I know is some stuff that is still being in process and being paid out as they're closing things out. Yours might be. With that said, you should have heard something and gotten some status update. If you go onto the website, you should be able to log in, like the website where you submitted the application. You should be able to log in and see a status there. There also should be a email or contact us on those pages as well for you to access. That would be the best, I would say, is try to reach out to them and say, hey, here's my file. What's the update? Nothing's changed in the processing. Do I need to assume that it's being canceled, or is it still in line to be paid out or whatever? And see what they say. If you hear absolutely nothing, because at some point in time they are just shutting down that office and that website and everything. If you hear absolutely nothing at all, then I would say you could probably assume that you can move forward and nothing has progressed, and you're going to move forward with the assumption that it was canceled and the tenant no longer has protections. But at the very least, do try to reach out to them first. I would probably even go as far before I served an official termination notice of some kind. Or whatever, or like we talked about, the balance due notice or whatever you do. Before I did that, I would probably go ahead and also follow up with the tenant and say, hey, I'm trying to get an update from that rent relief payment and I can't receive anything, haven't heard anything. Do you have any recent emails you can forward me with status updates and whatnot, and see if they come up with anything? And if you hear you've done both of those things and you hear nothing from the rent relief organization and you hear nothing from the tenant that gives you proof of, oh, okay, this is a different update since the last one that I received, and it does show that, yeah, they are still working on it. If you don't get any of those, then I would say you can probably assume it's not there. As far as legalities go, even if they are still working on it, the tenant is no longer protected and you're allowed to move forward. And it's up to you whether you accept that rent and they stay put, or you don't accept it and you move forward with eviction. So up to you. Should I send the delinquent debt notice to the tenant with the certificate of mailing or just email? It's an official notice, so you can't serve it electronically via email. So I would suggest actually doing both. I would send it standard first class mail, certificate of mailing, adding those 3 days for mailing. And we also send a copy via email. And the one via email is not the official. It's not the one that counts. It's not the one you can take into court to prove that you served it. That's the mailed one. But we do that, especially for termination notices like these, to where they have a certain number of days to act, just because even though we have to add the 3 days for mailing, we'll email it to them. They'll get the information a few days earlier, and who knows, maybe that gives them a better chance coming up with the money, right? So, but yeah, you can't any official notices in the whole state of Oregon, any official notices that have to do with like termination, non-payment of rent, violations, notice of entry to inspect. In Oregon, we do not yet have the right to serve any of those electronically. You can only serve them those 3 ways that we talked about. And it's also, just so I don't have to go through it right now, it's also spelled out clearly on all those sample forms that I provided in the slides too. So, okay, now we are done. Thank you everyone for sticking around. I appreciate it. Hopefully we'll see you in some future classes, and have a good rest of your day.